Welcome, everybody. It's a real pleasure to be here. It's a true honor to be able to introduce Richard Weisberg and Victor Schwartz at the Schwartz Lecture for Torts here at the University of Cincinnati College of Law. And I'm very excited about today's program for a couple of reasons. First of all, because I do have an opportunity to introduce a renowned colleague and a friend in Richard Weisberg. Richard is a professor emeritus at Cardozo and visited for a number of years at a number of prominent institutions. At virtually every prominent law school in the country, including the University of Chicago, Yale, and at Harvard, and has spent some time. We overlapped at the University of Pittsburgh School of Law, where I had an opportunity to get to know Richard and his wife Cheryl and become friends with them. Richard, when you pull up the bio, it says helped found, but I would say founded the law and literature movement here in the United States. And certainly law and lit owes a great deal to Richard and the work that he has done. Highly recommend a lot of his work. And he has actually a new book coming out called Law, Literature, and History, A Fateful Rendezvous with the Shoah. That will be published by De Gruyter Bill in May of 2025. So keep your eye out on that. Also, we will be hosting, thanks to the Law and Humanities Institute, in which Richard plays a prominent role, a conference on Melville. We'll be able to welcome Richard and Cheryl back then, and that will be next spring as well. We'll be hosting a conference on Melville and the law. I think everybody knows about, well, a lot of you know about Billy Budd and its relationship to law, but there's a great deal more. We'll have prominent scholars from around the country coming in, Sandy Levinson, Robin West, et cetera, as well as involving faculty from the College of Law from the university more generally. Today, Richard's not talking about any of that, but he'll be talking about a little bit of that, okay. But what Richard is going to be talking about really does relate to something that's actually quite important and really resonates with a theme that we focus on here at the College of Law. We talk a lot about justice. We talk a lot about social justice, and we talk a lot about injustices in the past that require restitution. And there's a big focus on that, obviously, throughout, a reckoning in American history. Richard's talking about this in the context of something that is very real. He's the co-founder, or actually the founder, I should say, of the Holocaust program at the Cardozo School of Law. And he's talking about a decades-long effort that he has helped lead, participated in testimony, court cases, et cetera, on the Alien Torts Claims Act and the ways in which the Alien Torts Claims Act has been attempted to be used and ultimately complicated by recent Supreme Court precedent to achieve some measure of justice for victims for descendants, in many cases, of victims of the Holocaust in terms of retrieving property that has been stolen. So it's a really important topic, and it is one that resonates with so much that we do here at the College of Law. I do want to make sure as well to thank and to make sure that I give an opportunity to another good friend, Victor Schwartz, whose generosity helps fund the Schwartz Lecture on Torts. That's why it's called the Schwartz Lecture on Torts. Victor's known for a number of things. First of all, anybody, if you were to say, hey, what's the torts casebook that you're using? Very often, the answer will be Prosser, Wade, and Schwartz, right? The Prosser, Wade, and Schwartz torts casebook is the leading casebook and has been, since I've been in law school, has been the leading torts casebook. Victor's stamp on torts law runs very, very deep. The restatement on torts and all the work in products liability that he has done, we're deeply indebted to him in that area. And I'm more indebted to Victor, despite all of that influence. The legacy that I inherit here at the College of Law, I'm more indebted to Victor by virtue of the fact that he was the dean at this College of Law. And something that Victor cares a lot about is making sure that the academic and doctrinal knowledge that we provide to our students is complemented with experiential and practical opportunities. And Victor is a real leader. He is a practitioner and a scholar, and he's a real leader in that space. I consider him a mentor. and I consider him someone to whom I very frequently turn for advice on educational process, on educational methods, on things that we can do better here at the College of Law. I'm very grateful for his mentorship. He's always very generous with his time. So I am going to turn it over to Victor to give a few words, and then we'll have the opportunity to hear more from Richard about this very, very rich topic about achieving some measure of restitutionary justice for property stolen during the Holocaust. Thank you very much, and Victor, over to you.
Hey, thank you, Dean. I just want to say to the students, I was just 26 years old when I started to teach. The students in the school treated me really well. The only criticism they had of me is that I had a New York accent, so I took a course in Babel and learned how to speak Ohio. I've contributed to the school, but I'm very proud of it now because the current dean is teaching you students who are there how to be good lawyers. A lot of the law schools now are giving what I call the law and me courses, where the professor, in essence, talks about herself or himself and what he believes or she believes, and not how to do your profession. If it were in the medical school, it would be a shock. And the dean is really doing good work so that you will be able to practice law in an effective way. And I'm very honored that the professor is here to give his talk, and I will hand it over to him.
Mike here. How is my voice projecting back there? Excellent. I see a lot of thumbs up. If you don't like the lecture or you no longer hear me, give me a thumbs down. Not necessarily in that order. Are we still okay up there? Okay. So I want to very much thank Victor Schwartz for being here virtually. I've never met Victor, but I do use his Torts book that the dean alluded to, and the set of cases in Prosser, Wade, and Schwartz. I teach torts. I've never deviated from using the book. Many of you, I hope, have had the chance to learn torts from that book. Is extraordinary. So this gives me a chance to thank Victor and of course, for the honor of giving this year's Victor Schwartz Lecture. Many other people to thank, and of course, my friend Haider Hamoudi, it's wonderful to see him. This law school, I will just tell you, having really been, in a way, someone that he took under his wing for a couple of years at the University of Pittsburgh, we miss him there. This law school is in very good hands and always has been a wonderful place. I think under his leadership, if anything, will move forward dynamically. And I thank him also for his kind words just now. The way that these kinds of events develop require a lot of help from people to make them work smoothly. And I just want to mention a couple of other people. Timothy K. Armstrong has just been wonderful in shepherding this process along. Administrative and logistical support from Andrea Starr and Angie Berry. Publicity, Sherry English, Cassandra Jeter Bailey, and the help of Tanya Hampton and Mike Whiteman. These people, and I may be missing others, I apologize for that. I also want to mention this lecture has given me the chance to get reacquainted with Burt Lockwood, one of the great figures of human rights who has worked tirelessly in that effort over many decades. He and I met because in volume 5 of his journal, Human Rights Quarterly, are you familiar with it, which is now in its 45th year, I believe, of continuous publication. That in and of itself is amazing. And in the 5th number of that journal, he published the proceedings of an event a very ambitious event at Brandeis University called Terror in the Modern Age. And we got to know each other then, and now we are back together thanks to this event. So I'm very happy that is part of the joy of this event for me. My topic, however, is not all that joyful. And I do want to tell you, maybe 45 minutes, if Q&A is less possible than we would like during the session, please remember there's a reception. That's usually even a better place to take your questions, which I would love to do. My story today contains 4 relatively short chapters deriving from torts and also common law reasoning at the federal court level. My expository chapter recounts a moment in the law of Holocaust restitution in the United States where the Alien Torts Claims Act, or the ATS, played a crucial role in bringing a measure of justice in the year 2000 to thousands of victims of French legalized banking theft during World War II. Apropos of the cites to statutes, there won't be too many of them, but one is the ATS. I think all of you, I hope all of you have what I will refer to as a short handout, about 7 pages. I'll be referring to that. For example, the ATS is cited. We'll get to that in a minute. And others of you have access to a longer set of materials, which is my congressional testimony apropos of World War II banking theft, which is available in hard copy, but also I think on your phones if you're interested in it. So most of my references today to help you just eyeball some of what I'm talking about will be to the short set of materials that you all have. The use of the ATS, the Alien Torts Statute, makes this topic entirely relevant to any discussion of torts. I'll be talking about the way in which the Supreme Court has, however, over a period of time, diminished the force of the ATS. And I'll be talking about another statute later called the Foreign Sovereign Immunities Act, which is a statute that deals with lawsuits also for Holocaust wrongdoing or other wrongs committed by foreign sovereigns. The suit in 2000 was brought against private entities, 23 French banks, as well as 2 American banks, JP Morgan and Chase, which had not yet consolidated, and a British bank called Barclays. All of these 26 banks were accused by the plaintiffs of ripping them off during World War II. Chapter 1 is largely about that. Chapter 2 is about this unworthy trend in SCOTUS, at least as I perceive it, spearheaded by Chief Justice Rehnquist a while ago and brought to fruition by his successor, the current Chief Justice, in a series of cases that have had the effect of virtually obliterating the use of the Alien Torts Claims Act for so-called extraterritorial claims, claims which took place abroad, were committed by foreign wrongdoers. The phrase extraterritoriality has made it difficult to bring these kinds of lawsuits, and we'll get to that in Chapter 2. Chapter 3, and here's where we bring in a little bit of the law and literature, digs down on the notion of piracy. Piracy was one of the main reasons why our first Congress promulgated the Alien Tort Claims Act. Part of that was against the wrong, the harms that pirates were doing, and the Congress gave aliens a right to sue in our federal district courts when harmed by piracy. So I want to talk a little bit more about piracy in the 3rd chapter. That's also going to help us bring in some Shakespeare. What would a lecture be without a little bit of Shakespeare? Namely, The Merchant of Venice, where piracy is a theme that is entirely relevant, as I think you'll see, also to the main lines of my talk today. And in the last fairly brief chapter, I'm going to fill you in on the Foreign Sovereign Immunities Act, a congressional statute of 1976. Also, we're in the process of seeing evisceration, weakening of the chances for Holocaust-related suits, but other suits as well that are brought under that statute. Now, take yourselves back the year 2000, whether or not you were even born yet. This is the time period of the lawsuit called Bodner and Benisti versus Banque Paribas. This case appeared in the Eastern District of New York in Brooklyn in front of Judge Sterling Johnson. And you will see Sterling Johnson's picture, and it's worth looking at on the last page of what I'm calling the short handout, which you all have. Could you just confirm with me, do you see the judge's portrait there in front of you? Sterling Johnson, prior to the period in which there was a defanging of the power of the ATS, recognized lawsuits brought by aliens in the Benisti part of the lawsuit, using the jurisdiction of the ATS. What were these American citizens in Bodner and the alien class of citizens, what were they saying about these French banks during World War II? Again, remember, it's important, 2 American banks as well, 1 British bank. 23 French banks and these other banks, according to the plaintiffs, ripped off the Jewish population in France under color of French law to the tune of hundreds of millions of euros. And the ATS was a mechanism by which some kind of, we call it a measure of justice, was being sought. And the Alien Torts Claims Act, an important element in this attempt. I'm a Francophile, despite what I seem to be saying here, and my interest in France originally had absolutely nothing to do with the Holocaust. Gradually, I got into thinking about what very few French people wanted to talk about with me, and that is the period of Vichy. That's a dark period, 1940 through 1944. The French had their own autonomous government. Most of the wrongdoing that we alleged in 2000 occurred under color of French law. I want you all to know that to the extent that you're interested in anti-Semitic legal attacks during World War II in France, this was done by the French. We showed, really North American scholars were among the first to show that German orders, diktat, was not really even involved. The French did the work, including the promulgation of over 200 laws and statutes against the Jews. They did that work themselves. It was a Franco-French phenomenon. And among those laws were laws that both defined who a Jew was under color of French law and eventually brought about the expropriation of those individuals who were unfortunate enough to be defined under French law as a Jew. The process of stripping a targeted population anywhere in the world of their assets, which we call expropriation in the trade, is part of a 5-step process that the great American historian Raoul Hilberg defined not only for Hitler's Europe, but for all genocides. All genocides involve 5 steps. They're all intentional, and they work step by step towards the final fatal treatment of the targeted group. The first step is definition. You have to be able to, this is the work of lawyers, you have to be able to tell people what the definition is of the group that you are intentionally moving to harm. Then there is isolation, imprisonment, Step 4 always is expropriation, looting. There are no genocides where there isn't intentional looting of the victimized group's property. That's what we were complaining about in the year 2000. And the final step is annihilation, extermination. That's what constitutes a genocide, a word that is often tossed around, I think today, a little bit too loosely. By mid-1942 in France, all of these steps had occurred, both in the occupied zone, that's where the Germans were, Paris, the northern part of France, and in the unoccupied zone that was formally autonomously governed by Vichy. The Vichy laws were so attractive to the Germans that they imported them to the occupied zone. Why were these laws attractive? Because the French were doing it themselves. Tremendous savings in manpower by the occupying power. When you have the indigenous country do the work itself, and the Germans really didn't have to do much, if anything, to nudge the French to do this work. That's a very sad story and something we can talk about, although it's a separate lecture in a way. Why did the French do this? Part of it was greed. That's the expropriation part of it. But by 1942 in France, Jews were also dying on French soil. 3,000 Jews died under color of French law in camps that were administered by the French, Vichy police, French prefects. 3,000 died on French soil. Others by 1942 were rolling in trains eastward essentially from Paris, having been rounded up, a violent, horrible story. And approximately 80 to 85,000 Jews on French soil under color of French law lost their lives, the final step of the genocide. Well, assets are nothing compared to human life, but there isn't anything you can do to get the human life back. What you can do, requiring very careful proof, is to show the expropriation, the theft, the looting of those assets. And I say we because I had recently published a book which had a lot of information about Vichy property law and theft, was invited by the lead counsel of Bodner and Benisti to become of counsel in that case. And the alien class was permitted to sue under the ATS. That's Benisti. Part of, I think, the success of our work in front of Judge Johnson, very careful judge, you have to prove everything, burden on plaintiff, very well paid, pricey defendants, lawyers. I don't know how many of you are going into big law. I'm looking out there. Any thumbs down on big law? Big law is fine. Those were our opponents. We were just a ragtag group of plaintiffs' counsel with a variety of talents and interests. We felt that we were making some progress, but like all judges, very carefully scrutinizing the many defenses that had been raised in a motion to dismiss in front of the judge that was decided in that decision in the year 2000. Part of our success, I think, was because of data, information, facts that I had amassed by interviewing people in France as early as 1983, and by finally getting into the French National Archives. I also had the help of a wonderful center in France that you should visit called the Jewish Holocaust Center on the right bank just off the Seine, the Centre de Documentation Juive Contemporaine. And in front of Congress, and that's the big document that you have, my congressional testimony, in 1999, I was invited with about 8 other people to talk about banking in France during World War II. It was the banking committee under Chairman Leach from Iowa. Several Ohio congressmen were there that day, including the hypothetical congresswoman who I will call Fiona. who was on hand and listened carefully to the testimony and asked some questions. 4 witnesses were there in the morning for, you could say, the plaintiff's side of things. And in the afternoon, the French got to speak up and try to explain, if they could, why the banks had behaved this way. That was tough sledding for them, and it was important because this was the banking committee, and their charge was from time to time to see if foreign banks doing business on our soil should be licensed, should their licenses be renewed. So it was an important day, and the story being told about French banks, obviously based on facts, was not a very happy one. Anecdotally, I'll just say that the 4 of us who spoke basically to show the committee the wrongdoing that we had found existed in the treatment of Jewish banking clients spoke in the morning. Then there was a break for lunch, and I saw a couple of French colleagues. I'd been dealing with them, but they were going to speak in the afternoon on behalf of the French side of things. And oddly, for the French, they were not taking advantage of the lunch hour. The French have a very long history of wanting a little bit of, well, wine at the lunch hour. I practiced a little bit in Paris. And I asked them in leaving the committee room why they were not, they just looked shell-shocked by what they had heard in the morning. Very tough for the French. A lovable, wonderful people. I know a few of you are going to Bordeaux in a couple of months. I envy that. This is a law school that has ties and should with France. But this is a terrible period for them, and they didn't like what they had heard, and they were white, faces ashen. I said, please go to lunch. This is Washington, D.C. You know, it's not Paris, but you can find a nice restaurant. But they didn't want to do it. They just sat there until they hoped they could hear testimony a little bit more favorable to their cause. We showed that the French banks had jumped the gun in punishing their Jewish banking clients who had a desperate need during these years just to gain access to their bank accounts to try to get out. Because by a certain period, they knew that the ultimate step in the process was extermination. And the banks blocked their bank accounts. You couldn't get into safe deposit boxes. And we had the evidence. We had, especially important on page 163 of the bigger set of materials, you'll see what we call gun jumping. This was crucial. The French Banking Association in 1941, prior to any law or regulation forcing them to do this, again, page 163 of your materials, sent out to all of their members, big banking organization, powerful, and told them to start blocking Jewish bank accounts. Even if, and I'm quoting from their circular, even if the projected ordinance has not yet been promulgated. Well, we call that gun jumping, to use that metaphor. Wrongdoing takes place prior to any official requirement of it, jumping the gun. This was a very, very damning thing that the banks saw it in their self-interest to move ahead rapidly before any ordinance or law even came out. What were they doing? Blocking Jewish bank accounts, keeping safe deposit boxes sealed. People couldn't get in even to get their precious family elements like candlesticks and other things that were important. A terrible period, and the banks did this without any coercion being brought to them either by the Nazis or Vichy when they did that. There are 2 other metaphors connected to guns. I'm sorry, usually lawyers have a much more docile lexicon besides jumping the gun. And those are smoking gun. You're aware of that? Those of you who are going into litigation or are litigators, that's what you want to find. You want to find the smoking gun, the thing that absolutely pins down your case. And the smoking gun here was a questionnaire that these banks sent out to all of their clients. We had it on the record, individual and corporate clients, which basically wanted to find out if these clients were Jewish. So they sent questionnaires out, and under Vichy definitions of who is a Jew, remember, definition is the first step. Based on grandparental heritage, if you're a client at Banque Paribas, Crédit Lyonnais, or any of the big banks, they still exist in the same form today. You're getting a letter from your bank and it's saying, how many Jewish grandparents do you have? How many non-Jewish grandparents? Are you a practicing Jew? Vichy law dictated the method by which the banks determined on their own who was a Jew. And for a corporate, there was a maximum number of Jewish directors that were permitted. For an individual, it meant that, boom, you no longer could have any access to your account. The smoking gun was this questionnaire. The banks are saying, well, we didn't know anything. What could we do, et cetera, et cetera. Smoking gun, gun jumping, and the third violent metaphor that we lawyers sometimes use with the word gun involved is gun to the head. Have you heard that one? This is a phrase that's maybe used by all of us when somebody has kind of nailed us down on something that we're kind of ashamed that we did, right? Which we all do. And you might say, it wasn't me. There was a gun to my head. Somebody was forcing me to do it. And of course, throughout the time in front of Judge Johnson, the banks were saying consistently, well, we didn't think we did anything wrong. Maybe there's some evidence that we did. We had to do it, gun to the head. What could we do? We heard it over and over again. Long story short, gradually Judge Johnson, one of the most careful judges I've ever appeared in front of, he got wary, he got skeptical about these kinds of statements that the banks were making. And happy ending for our clients, we prevailed in the district court in 2000. It took only a few months after that for a settlement in the case to take place outside the beautiful State Department headquarters of then Secretary of State Madeleine Albright. Have you heard of her? A wonderful Secretary of State. We had a signing ceremony, and you'll see that on the, I guess, the second to last page of the short handout. You'll see me signing, all of the parties signed under Stuart Eisenstadt, who was a Deputy Treasury Secretary in the Clinton years. This is the last few weeks of the Clinton administration, January of 2001. And you see Stu Eisenstadt in that picture as well. Stu Eisenstadt, really one of the great heroes of the story of restitution, much more broadly. And the case settled. And then I had been an adversary, but for the last, really since then, 22, 23 years, I've worked with the French in a more diplomatic and friendly way to provide individual restitution through their mechanism, through their agency in France, to those who had been wronged. So money is being repaid. Lives can never be brought back. Lives that were shattered anyway. A measure of justice, not all that important except in the symbolic sense that, in this case, an American judge is listening to a series of stories that are on the record of how families were disrupted. It's inconceivable unless you really focus on it, and the claimants all were able to give capsule stories to judges here in the United States, which I think was important, as important to them as whatever they may have received in terms of actual restitution. And the banks had to pony up. It's a terrific day, a terrific day. But as far as the ATS, the Torts Claims Act, short-lived, because my second chapter, 2 Chief Justices defanged the ATS. Many of you know that the ATS, Alien Tort Claims Act, does not have a lot of power left in it. With a kind of forensic precision worthy of your best dentists here in Cincinnati, various courts about 4 years after our case started to pull the teeth out of the ATS. Chief Justice Rehnquist, not one of my favorites. I've written about Chief Justice Rehnquist, many strains. Chief Justice Rehnquist was in the vanguard in a case called Sosa, where in a concurrence, the Chief Justice with Scalia and Thomas writing for him, said that the Supreme Court, and this is 2004 or 5, the Supreme Court should recognize that there are some matters, these are the words of the concurring judges, some matters, any matters, are none of its business. Now, think about it, there's a certain plausibility. Why should claims that took place, put aside long ago, but claims that took place extraterritorially, by foreign defendants, what business is it of the United States courts, they were saying, to even think about these claims? None of our business. To the extent that that message wasn't getting through, Rehnquist's successor and protege, the current chief, made it explicit in a case called Kiobel in 2013 that there was a presumption against extraterritoriality that plaintiffs had to overcome. Chief Justice Roberts has ever since been in the lead in expressing and implementing his fear that Article III judges should not be making decisions about these kinds of cases for a variety of reasons. The notion that even the most heinous torts must be presumed unsusceptible to U.S. federal court jurisdiction did not go down easily. One of the major critics is a very fine judge on the Second Circuit Court of Appeals named Pierre Laval. He wrote a couple of contemporaneous articles in which he suggested that the idea that U.S. courts should go out of the business of entertaining claims, even based on heinous acts, ran counter to an entire opposite tradition of what might be called universal jurisdiction. Then when it comes for violations of certain basic norms of human rights, all courts have jurisdiction. And Laval was saying, the American courts, I'm part of it, but the American court should not be going out of the business of entertaining claims that are basic to post-Nuremberg standards and norms of judicial remedies for atrocious harms. I think it's worth reading, and in fact, Justice Breyer, concurring in Kiobel, actually cites one of Pierre Laval's articles, the one that appeared in Foreign Affairs. And Breyer does not accept the notion of extraterritoriality in Kiobel, but that is the current law about a presumption that's very difficult to overcome that has been added to the ATS. Extraterritoriality, I want to talk about that a little bit in my third chapter. Next two chapters reasonably brief, but I want to bring in Shakespeare. And chapter 3 is called Vichy era theft as modern day piracy. Now remember that first Congress that passed the ATS long time ago had in mind piracy as one of the ills that they wanted to protect against. They may very well, because they were influenced back in those old days by 3 primary sources of law. Blackstone, of course, the Bible, Shakespeare. And I'm going to bring in some Shakespeare to just enliven your imagination. What exactly is piracy, and does piracy exist these days? Answer, yes. Piracy is mentioned by Shylock the Jew as a way of describing the harms that occur to Shylock in The Merchant of Venice. And in the first act, this is the way Shylock, who's really a master at using language, every actor wants to play Shylock, every actress wants to play Shylock. I would like to play Shylock. Here's what he says about piracy. Ships are but boards. Cast your imagination on the high seas. Sailors but men. There be land rats and water thieves, and land thieves. I mean pirates. And then there is the peril of water, winds, and rocks. Piracy is an image of the risks that commercial people on the high seas were threatened by. As the plague continues, it turns out that Shylock's wealth is stripped from him, and the looting that takes place of the Jew, whatever else may be going on in the play, is a major element there and a form of piracy, legalized theft. What happened in France to the Jewish population as committed by these bankers was a modern day form of piracy. So the framers of the ATS were thinking of something actual on the high seas. It was taking place, but they, projecting forward, are precisely describing a form of modern day piracy that takes place on land. Extraterritoriality is like a complete phantasm, because to say that pirates were acting in an extraterritorial way, to make a very uneasy analogy, pirates were often on ships that were registered to actual countries. Pirates had to go back with their loot to countries like France or England or wherever they set down, United States, South America. Extraterritoriality doesn't make much sense as a restriction, although that is where we are in terms of the doctrine on the ATS. Finally, in the short version of your materials, right on page 1, you have the operative sections of the Foreign Sovereign Immunities Act. Now, this is the second major act that I wanted to talk to you about today. And what you're seeing is the following. The Foreign Sovereign Immunities Act, FSIA, is a mechanism that plaintiffs' lawyers have about theft when they are suing sovereign and not private wrongdoers. Got it? Foreign Sovereign Immunities Act. Generally, sovereigns, as you may know, are immune from the jurisdiction of federal courts. But what you see in front of you are 5 exceptions to that immunity. 5 exceptions that we have. I'm still litigating a case in Chicago against Hungary and its national railroad for deportation and looting of Jews from Hungary in 1944. It's a horrible, separate story. Litigation continues under the FSIA, even though the ATS has been largely defanged, and problems have arisen in terms of plaintiffs' use of the exception. The most important one is 1605A3, you can look at it later, which is called the takings exception. If a sovereign or one of its entities takes property in violation of international law, then the sovereign or its entity, which could be a railroad, no longer has immunity. That exception has been useful in a number of cases for plaintiffs. Still, it's a civil suit. Nobody's going to jail. Same thing like we had in 2000. But the state of play now, I just want to tell you, under Chief Justice Roberts and the court, is that the FSIA also is being largely stripped of any significance. This is a policy of the court. And keep your eye out, because cases are actually pending out of the DC Circuit. And the Supreme Court, for the second time in 3 years, has taken certiorari in these cases, and their first set of holdings not very helpful to plaintiffs. I'm talking about the Phillips case in the DC Circuit against the Republic of Germany and Simon versus the Republic of Hungary. in the Q&A or informally, be happy to answer more about what's going on. For a second time in 3 years, the court has just taken certiorari about the same statute. They almost never do this. And the questions that they have certified bid fair to render a complete end to the possibility that even if an exception has been shown, that the court will be allowed to take jurisdiction against a sovereign or an entity. So that will be the, effectively speaking, though we're still fighting, that'll be the end of these lawsuits. That is the current trend in the court, a very powerful trend. Leave us alone. We don't want this stuff. There are matters, any matter, to use Rehnquist's words and his colleagues, which are none of our business. In conclusion, I want you to think about this and ask yourself whether, not only as related to Holocaust asset restitution suits, but in general, our federal court should gradually be moving out of the business of handling claims of this kind. Some of them involving the 5 steps towards genocide, others involving rape, looting. A Nigerian set of plaintiffs were thrown out of court. And what can you do yourself if you are interested in following this and now better informed, a little bit upset about it? So thank you for your time. Do we have time for a little?
Yeah, I think we do. Thank you, Richard. I mean, it was a really powerful lecture, and I think an opportunity for a lot of engagement. So, but please, we do have time for a few questions. Louis, please.
Is there any other country in the world where these cases could be brought?
The answer really historically has been no. When these suits are brought in the country of the actual wrongdoing, for example, many of our clients had tried their hand in French courts. They have not met any success in the domestic court, but that's really understandable in a sense. It's a longer story, but the answer to your question is, let me modify that a little bit. I think there are jurisdictions, Spain comes to mind, unrelated to Holocaust claims, which have asserted universal jurisdiction. So it's not an absolute no to your answer, but the United States has been in the forefront historically. And now we're not. We're in the back front, if that makes any sense. Getting back to my teeth analogy, we're in the back front of here, tooth number 2, about to be pulled. Thank you for the question.
Thanks for coming in today. My name is Alex Mayanja, and I'm a 3L. I do have a question. I'm sorry?
Nice to meet you.
Pleasure to meet you too. So my parents are African immigrants, and so hearing much of this it spurs a lot in the sense that there's a lot of things that have been done throughout time that are not always answered for, and we understand that, and you as well as anyone else. Do you believe that the strategic dismantling of both of these acts is due to potential concerns of reparations by, African nations, but also the possible transmutation for reparations by African American citizens?
The answer is yes. The answer is yes. These strategies are fungible. I'm understanding your question, what about reparations for harms that have taken place in this country, right? Essentially.
That and African nations as well.
And yeah, it is obviously a very, very long story. You may be aware of efforts that are being made. They have contacted us historically for advice about how to proceed. It's very, very different, but there are some real similarities. So I appreciate your question. We should talk more about it, if you like, later.
Yes, please. Thank you.
Of course.
Hello, I'm Carson. I'm a 1L.
I can't hear you.
Is it working now?
Yeah.
I'm Carson. I'm a 1L, and I was wondering, to what degree does the current French government recognize itself as responsible for the actions of Vichy, and does that make litigating your cases more difficult?
Excellent. It's a question. It's part of the background of this case. The denial of any French wrongdoing by French leaders from Charles de Gaulle, you know that the great general, a terrific individual, very powerful communicator. And de Gaulle wanted to console his countrymen after the liberation of France by essentially saying, except for a few wrongdoers that we can isolate out, the rest of the country was not responsible in any way for the genocide, which is really what it was. He didn't use that word. And the Gaullist view that consoled a lot of my friends who had no culpability, but they didn't want to talk about this period, lasted until 1995. Leader after leader said, we were not responsible. Until Jacques Chirac, a president in 1995, finally, in a very famous speech, took responsibility and said, France is responsible for these harms. That was an amazing breakthrough and possibly played a role in our success a couple of years later, although it wasn't really part of our legal theory. Does that help? Does that answer that question?
Yes, thank you.
You want to follow up? Are you going to Bordeaux? You can find out more.
Never get the chance.
Thank you for the question.
Were any American financial institutions ever held accountable?
Thank you for that question. I mentioned Chase and JP Morgan, and this is a pretty good story that involves a great American lawyer named Floyd Abrams. Have you heard of him? He's much better known for First Amendment work. Please try to, he's still active, Floyd Abrams. Floyd wound up representing JP Morgan and Barclays. His firm did the banking business for them, big firm in New York. Floyd was brought in, and I showed Floyd what I have called today the smoking gun, because he said to me quite reasonably, we knew each other from First Amendment events and a friendship. And he said, Richard, no, he said, Richard, I just don't get it. What could JP Morgan and Barclays have to do with these events in France from 1940 to 44? We had the questionnaire from Barclays. And he said, that's kind of interesting, sending out to all clients on French soil, questionnaires tending to show, are you Jewish or are you not Jewish? It's kind of, I wouldn't have expected that. And to his credit, he went back to his clients. You almost never get this. And he said, we need to look into this. And it took about a year. And the plaintiffs did not have to expend anything on this. And we were quite busy with the mainline defendants. And in about a year, much to his credit, a remarkable story. He's very modest, never gets told. Although there have been books written about what I've talked to you generally about today, including by Eisenstadt, called Imperfect Justice. Floyd came back and he said, we have found out that we, in fact, expropriated assets from a small number of clients, both JP Morgan and Barclays clients, maybe 90 or 100 in each case. And they came to the settlement table separately from the main line of clients. That took till January of 2001 and Judge Johnson's decision in the main case that I've talked to you about largely today. So that was absolutely also a great day. Justice had been done. It was an American bank. It was a British bank. The Chase lawyers decided to hold on and play hardball, but they eventually also had to see the light of day. But I like to mention Floyd Abrams, who is a great man of the law anyway, in this regard. Thank you for the question.
Hello, I'm Kyra, my first year.
How are you?
I'm good. How are you?
Pretty good.
I was wondering, would this apply also to what's happening in Palestine by any chance? Because it seems pretty similar.
Well, I would be a very long story, separate lecture, separate set of discussions that we could have together. But the one thing I feel very strongly about and alluded to in my lecture is that as horrible as the suffering is in Gaza, Israel is not committing a genocide there. That is the one thing I would like to very much ask people to be careful about. This
What are
is
they
not
doing?
a genocide. This is, not an intentional infliction on a native population designed to exterminate it. So when I said I think the word is being used loosely today, that's partly what I had in mind. Are there terrible wrongs? Are there potentially war crimes going on? Is the situation horrible to witness in Gaza? Yes. Am I a fan of the current government in Israel? Definitely not. But this is a separate subject, and the one thing I want to say in the spirit of my own remarks today, we have to be careful in using a word like that.
Where would you draw the line then if it's not similar?
I think what you need is what is exemplified not only in Hitler's Europe, but in other places where it's still going on. And it's the intentional infliction of this five-step process where your intent is to annihilate a population. And it's very complicated. I've spent time in the Middle East. I've negotiated with Palestinian leaders and professors a long time ago on the West Bank. I think there's great hope. If there were a way of, and this requires leadership, you're not going to get it from the current Israeli government. Are you going to get it from anybody on the Palestinian side? I don't know. Will you get it from the current administration that's coming in? I don't know. It's an entirely complicated subject, but you are not, the Israelis are not intentionally committed to wiping out the Palestinian population. They're doing a lot of harm. It could have been done better. They were provoked. October 7th did take place.
Yes, I'm aware of that, but there was also conflict for years before October 7th as well.
I'm with you probably 2/3, maybe 3/4 of the way. Don't like the current government, have friends in Israel who are very upset about the government for a lot of different reasons. Not a genocide. That's all I want to say. And that's because of the topic today that I have been dealing with.
Thank you for your time.
Separately, we would have to talk for hours and hours, which I would welcome. Thanks to all of you. Great audience. Appreciate it very much. Thank you.